with Doyles Construction Lawyers, and we specialise in construction law, both in setting up construction contracts, in looking after the management of construction contracts as they're executed, and in resolving disputes at the end of the job. I'm to speak to you today on some recent cases which have been handed down by the court in a number of areas, but particularly in respect to the security of payment legislation. And the first case that I'd draw your attention to is Bauen Construction Pty Ltd Sky General Services. It's a 2012 case in the New South Wales Supreme Court. In this case, there was a challenge by Bauen Constructions to an adjudication decision which had been handed down, and a number of interesting issues arose in the court's decision. The first issue was whether or not the payment claim which underpinned the adjudication success was out of time. As you may recall, the Act provides that a payment claim must be brought within 12 months of the work being undertaken. Despite the contrary contention by Sky, Bauen Constructions were successful in establishing that the work was out of time. The court went on to consider whether or not the error by the adjudicator in determining that the work was within 12 months of the defect's liability period was an error within his jurisdiction or an error of jurisdiction. The court decided that this was a fundamental matter that must be successful before an adjudication could be soundly based on it. Accordingly, the court set aside the adjudication for the reason that it was not within the appropriate time. The court also considered a second aspect, and that was whether or not a payment schedule submitted by Bauen Constructions had been properly lodged with the nominating authority. The issue was whether or not the adjudication response had been received by the nominating authority within the required time under the Act. The facts are accepted that the adjudication response had been served by email. The adjudication response had unfortunately been allocated to the spam folder and had not been accessed by the nominating authority. The court considered a number of authorities but decided that the email had been lodged as required under the Act and therefore should have been accepted and considered by the adjudicator. There are two important practical conclusions we should draw from this case. One is that the payment claim should be submitted promptly and well within the statutory limit of 12 months. The other is that when depositing or lodging or serving documents by email, one must be careful to ensure that the email addresses are correct and that the email has been received. Conversely, for those receiving emails, they must be careful to ensure that what ends up in their spam folder does not create a substantial legal liability. Thank you.